Lesson 40, Landmark Fifth Amendment Supreme Court Cases. The iconic case for the Fifth Amendment with respect to due process was the 1966 case, Miranda versus Arizona. Background of the case: March 13th, 1963, Ernesto Miranda was arrested by the Phoenix Police Department based on circumstantial evidence linking him to the kidnapping and rape of a 17-year-old girl just 10 days earlier. After 2 hours of police interrogation, Miranda signed a confession to the rape charge on forms that included the type statement, quote, "I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me." At no time during this process was Miranda told of his right to counsel. He was not advised of his right to remain silent, or that his statements would be used against him during the interrogation. Before being presented with the form on which he was asked to write out the confession, he had already given orally. None of this was made known to Miranda before he signed the confession. It's very important to know the chronology of what happened in this case. At the trial, when prosecutors offered Miranda's written confession as evidence, Miranda's court-appointed attorney objected because of these facts. The confession was not truly voluntary and should be excluded. Moore's objection was overruled, and based on this confession and other evidence, Miranda was convicted of rape and kidnapping, sentenced to 20 to 30 years in prison on each charge, with sentences running concurrently. Miranda's attorney filed an appeal to the Arizona Supreme Court, claiming that Miranda's confession was not fully voluntary and should not have been admitted into the court proceedings. The Arizona Supreme Court affirmed the trial court's decision. In affirming, the Arizona Supreme Court emphasized heavily the fact that Miranda did not specifically request an attorney. When the case came before the Supreme Court, Chief Justice Earl Warren wrote the majority opinion. Now, Warren was a former prosecutor. Keep that thought in mind. The Warren court ruled that due to the coercive nature of the custodial interrogation by police, no confession could be admissible under the Fifth Amendment self-incrimination clause and the Sixth Amendment right to an attorney, unless a suspect had been made aware of their rights and the suspect then had waived them. Quote from the majority opinion written by Earl Warren: "The person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent, that anything he says will be used against him in court. He must be clearly informed that he has the right to consult with a lawyer and to have the lawyer with him during interrogation, and that if he is indigent, meaning poor, a lawyer will be appointed to represent him." So these are the so-called Miranda rights. These are taken almost word for word from Earl Warren's majority opinion. You've probably heard these when you watch any Law and Order or court television show when a person is arrested. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand each of these rights I have explained to you? Having these rights in mind, do you wish to talk to us now? Following the Miranda decision, the nation's police departments were required to inform arrested